I would just like to again thank Professor Ung and Professor Jacobson for coming here and for preparing this delightful article that they're going to present to us. And as they get set up, the reason why we decided to put in this prize was twofold. One is that we wanted to highlight the excellent level of scholarship that is going on both within ASLE and the journal. And so hopefully this will give you some indication of that excellent scholarship. A second purpose, I think, is for everyone who comes to ASLE, but especially the younger scholars in the room. I think it's important to see what excellent scholarship is and to give sort of a benchmark. And maybe some of you will see this and you'll say, this is terrific, and I also can do this. And if you say that, then please submit to the journal because this is an excellent piece. I would like to say that in terms of impact so far, of course, this is an article that hasn't been out that long, but it very quickly went up to well over 1,000 downloads through the journal. And I personally have received comments from many different people in many different fields because this is a cross-cutting topic that affects many different areas of the law. So the title, as you can see, is How Global is the Common Law? A Comparative Study of Asian Common Law Systems, Hong Kong, Malaysia, and Singapore. And now I would like to turn it over to Professor Ung, will present part of it, and Professor Jacobson will present another part. They are limited in time because this is a large forum, so they will try to do this in a record speed of maybe 15, but maybe 20 minutes, and then we will have time for questions after that. But I would like everybody to just warmly welcome and congratulate them with a round of applause for what I'm sure will be a terrific paper. Thank you.
Thank you, Dan, for your very kind words. It's a great honor for Brynna and I to receive this award and to come here to present our work. How global is the common law? That seems to be quite an obvious question. About 1/3 of the world's population live in common law countries. But you know, when we talk about, or when we try to think of, when we try to think of the common law, the existing literature usually focus on some of the usual suspects. England, of course, you know, the original common law, and the United States. As a law student myself, I read my fair share of judgments from Lord Denning or, you know, Justice Cardozo. But as we know, there's a lot more to the common law than, you know, the wealth of materials from England and the United States. And sometimes we include Australia, New Zealand, and Canada. And so we pay a limited attention to other common law jurisdictions. And also, when we study the common law, we focus on limited numbers of courts and cases. Usually, we focus on the highest court of certain jurisdictions, and we study a certain type of cases, such as constitutional cases. What we are trying to do is to explore the global nature of the common law by turning the table, by looking at the common law systems from a different part of the world, from here, from Singapore, from Malaysia, and from Hong Kong. And just to preview the findings of our paper, we would suggest if we look at the way foreign citations are used, and we study foreign citations to understand the global nature of the common law. That is to say, we are not talking about a lot of parallel common law systems that are creating a world of its own, but they are a shared tradition. They borrow from each other. If we look at that from that vantage point, then we see Hong Kong, Malaysia, and Singapore as the most global, outward-looking jurisdictions. And we have that conception that the common law is a system of local knowledge, extension of local customs. And I would say that that imagery fit the description of the US and the UK system, because when it comes to the US and the UK, foreign citations are rare and, in a sense, controversial. I mean, it is a kind of like a boutique practice by some nerdy judges. When they use the foreign citations, they use it on some very special, in some very specialist sense. And then there's the Canadian model or the Commonwealth model. In the words of the late Canadian legal scholar Patrick Glenn, foreign citations is a kind of a persuasive authority from abroad. But then you have the Asian common law model. By that we mean Hong Kong, Malaysia, and Singapore, which is the most globally outward-looking, a very global system of law. So let me talk about, thank you, about the common law in Hong Kong, Malaysia, and Singapore. They are established, they are influential, they affect other local legal system, and they are legal system of general applications. So the common law is the law of general application. They do not confine to a specific sector of law, and they apply to the entire population of the jurisdiction. The way we do our studies, we study all the reported cases. So this is the entire corpus of law. We focus on the major journals of the 3 jurisdictions. We study 3 years of reported decisions. You can see the total number of decisions we study. And just to give you a certain set of background, the 3 jurisdictions are comparable in the sense that they all become independent jurisdictions towards the end of the century. In the case of Hong Kong in the 90s, and in the case of Malaysia in the 80s, and Singapore early 90s. So there are 3 research questions guided our study. We want to ask, how prevalent are foreign cases in the 3 jurisdictions? So are foreign cases often used? I mean, this is a simple question. You just need to search and look and see how often foreign cases are used. And then the second question is, to what extent is citing to foreign cases a contemporary practice as opposed to a legacy practice? That means we want to see, do the 3 jurisdictions still cite to foreign cases? Or is it because when we call foreign, we mean some old English cases of the 18th century or 19th century? So we want to take a look at what is the character, what is the nature of citing to foreign cases? Is it contemporary or a legacy? And the third one is, and this is by far the more complex of the 3 questions, what are the roles and purpose of foreign citations? So this is how we do it. We include all the courts that have reported judgments. We include all the reported cases, and we study all categories of law, as I said, and the entire corpus of case law. And the way we do it is to, identify and optimize a list of search terms, and then we once run searches within the major legal law report of each jurisdictions, and then we try to identify the proportion of reported cases with foreign citations. So the search terms, they include international law terms like certain major convention. We also include country names. We also include abbreviations of law journals and the names of major law journals. And we try a few times, and we are pretty confident that the list of search terms we include cover quite extensively, even if not exhaustively, all the foreign law citations of the cases we study. We do random sampling, so we have only two people, so it is a little hard for us to read through all the cases. So we pick 10 to 15%, that's our sample rate. And then we read and code each case. And we read each case quite carefully. I would say we do comprehensive quantitative and qualitative analysis. And so we try to understand, what kind of foreign cases are cited and why and under what circumstances foreign citations are used. And so we try to capture that kind of case-level granularity in our analysis. Altogether, there are 45 data categories recorded for each case, and we analyze the patterns and trends based on our qualitative and quantitative analysis. So let me offer you some big picture, and then Brynna will further explore the use of foreign citations. I have two things to say. First, in terms of the prevalence of foreign citations, you can see it. It is very, very prevalent. Over north of 60% in the case of Hong Kong and Malaysia. So it is not a boutique study. It is not a boutique practice. It is not just one or few idiosyncratic judge liking to use foreign citations to show off themselves. It is an everyday common practice. And in the case of Singapore, here, 86%. So it is much more common to use foreign citations than not to use it. And next, it is not just about the percentage of cases with foreign citations. It is also the depth or the breadth of foreign citations. On average, when you see a judgment with a foreign citations, it is not just one or two cases that are cited. In the case of Hong Kong, 4.8%, Malaysia, 6.7%, and Singapore, almost 9 cases cited in each judgment. So I will ask Brynna to further talk about how foreign citations are used.
Thank you. So, given how remarkably pervasive foreign citations are in these jurisdictions, we wanted to better understand the phenomenon. So we asked, to what extent is citing to foreign cases a contemporary practice as opposed to a legacy practice? Do jurists embrace voluntary reference to non-binding foreign decisions? Or is foreign citation merely a colonial legacy, especially given the relatively recent right of final appeal to the Privy Council, and hence actually a form of binding precedent or stare decisis? Prodding the hypothesis of colonial legacy, we do see that English decisions constitute the largest single group of foreign cases cited in Hong Kong, Malaysia, and Singapore, with approximately 61 to 82% of total published cases, including some citation to England. Within our sample, about 96 to 98% of cases included one or more citations to English jurisdiction, highlighting British judicial influence. However, to better understand the nuance of British citation, we differentiated between English citations by dates, either before or after each jurisdiction's respective break from the Privy Council. We can see here that a high percentage, about 90% of sampled cases, include citation to the earlier English cases. This makes sense as the date range includes hundreds of years of precedent from which to draw, and includes the period of formal colonial relations. What is even more interesting to us is the substantial citation rates to later English cases from dates after that break, which only include a few decades of cases at most and constitute entirely voluntary citation. Moreover, if we use a strict definition of binding English precedent as only local cases on appeal to the Privy Council, we see that such binding precedents constitute only a very small minority of English decisions cited. For example, that would be 9 out of 489 total citations to England contained within our Hong Kong sample, or 13 from Malaysia, or 4 from Singapore. Now, looking beyond England, there are substantial citations to other foreign jurisdictions which Hong Kong, Malaysia, and Singapore judgments cite in an entirely voluntary capacity. 35% of sampled cases from Hong Kong included non-UK foreign citations. Malaysia and Singapore included much higher rates of citation to other foreign jurisdictions at around 65%. Individual judgments, of course, may include a range of foreign citations from various jurisdictions. These are the jurisdictions cited within our sample. Of course, England is the most cited foreign entity, but there is substantial citation also to Canada, India, and Australia. There is citation between Singapore, Hong Kong, and Malaysia. And all three, for example, cite with varying frequency to the United States, New Zealand, and Scotland, and other locations seen here. So, given this very high rate of voluntary citation, as well as its broad range, both temporal and geographical, we characterize the practice of these jurists as judicial cosmopolitanism. In our paper, we also investigate how foreign citations are used within the judgments. For example, we examined the relative rates of treating foreign cases in affirmative, neutral, or negative manners. We found that foreign cases are often used as sources of legal authority, and as we see here, a vast majority of cases included at least one foreign citation used in an affirmative manner, supporting the judicial reasoning process. Neutral and negative citations were less frequent, but still quite significant. Notably, we would sometimes observe a sense of obligation expressed by a judge in explaining divergence from foreign precedent. Neutral and negative treatment within judgments can also highlight the role of counsel in engaging with and introducing foreign material. So far, we have generally been speaking about the three jurisdictions in the study as a group, so I'd like to take a moment to highlight some of the distinct characteristics and variations we found between citation practices in Hong Kong, Malaysia, and Singapore. Starting with Malaysia, where we found foreign citation to be very prevalent, with a notable absence of boundaries between domestic and foreign citations, which were often used concurrently in judicial reasoning. Detailed analysis and extensive quotations from foreign sources was common. Our sample indicated that Malaysian judges show a particularly strong sense of esteem for foreign cases, with only 8% of sampled cases including any negative treatment of foreign citations. Singapore employed the broadest array of foreign jurisdictions cited, however, with a stronger distinction between domestic and foreign cases than was seen in the Malaysian sample. Singaporean judgments were also more likely to distinguish or depart from cited foreign cases. Singapore was unique among the three by including a greater number of substantive rather than procedural uses of foreign citations. The youngest independent jurisdiction studied, Hong Kong judgments, were much more likely to include only English foreign citations, with 66% of sampled cases citing directly only to England without any other foreign citations. Overall, within our 3-year period sample, Hong Kong judgments tended to stay the closest to English decisions and cite to the fewest number of other foreign jurisdictions. Despite these variations, what we see in all three of these jurisdictions is first and foremost a distinctly outward-looking global approach to common law, with over 60% of reported judgments citing to foreign cases. This far surpasses the Canadian Commonwealth model in a cosmopolitan approach. As such, foreign citation is an entrenched vital practice in these legal communities, providing an institutionalized mechanism to import new ideas and contents into domestic law and contribute to legal and professional enrichment. Notably, foreign citation as practiced in these judiciaries is cosmopolitan, including contemporary citation from a rich variety and range of foreign sources, displaying a high degree of voluntary citation, not explained by colonial legacy alone. Finally, our study points to how foreign citations permeate the corpus of the law in these locations, not limited to the highest courts or particular subject matters, but rather the entire body of reported cases in Hong Kong, Malaysia, and Singapore. So that's our paper. Thank you so much for your attention today, and thank you to Dr. Puchniak and the Executive Editorial Committee of the Journal for this honor. We're so happy to be here.
Yeah, thank you very much to both of the authors for a fascinating presentation that I think is equally as good as the written work and exciting. I have limited time because we're on a very tight schedule, but it would be good if there's a question or two from the audience, we can entertain it at this point in time. Are there any questions?
On the slide where you showed various jurisdictions whose decisions courts in Hong Kong, Malaysia, and Singapore were citing most frequently, there was also a reference to the European Court of Human Rights. And I was wondering, how come? Why is it exactly the European Court of Human Rights that is referred to most frequently? Not another regional human rights court, not another international court, but precisely the European Court of Human Rights. Thank you very much.
Thank you for the question. I think some of the reference to the European Court of Human Rights came through the pathway of some English cases that have to refer to the European Court of Human Rights for their decisions, or make reference to it. And so in those cases, the judges in Hong Kong, Malaysia, and Singapore also make reference to the European Court of Human Rights because of that. Yeah.
Just a few comments. Well, first, did you look at the breakdown between superior courts compared to inferior courts? Because obviously in this stricter English version of the common law, the higher courts set binding precedents more strictly and apply them. And the other question is, have you looked at different time frames? Because I'm reminded of a book comparing actually international arbitration cases based on the model law in Hong Kong, Singapore, and Australia by Dean Lewis a few years ago. And what that showed is that, at different eras, these different jurisdictions were more internationalist in terms of how they approached the interpretation of the same underlying model law on international commercial arbitration. So I wonder if that could also be a pattern that you've looked at or are thinking of looking at. And I have another point, but I'll leave it for now. Thanks.
Thank you very much.
Thank you. So to answer your question on the question of superior and inferior court, I think in the case of Malaysia, many of the foreign citations were cited by some of the, not the highest court in Malaysia, but one tier down or one tier further down. They were referred to when they referred to some of the court cases by their superior courts. And the superior courts have make it a habit to reference to a lot of foreign citations. And so there's that particular tendency of what we call embedded citations. So when they cite to their superior courts, they inevitably cite to some English or Australian or Canadian cases because their superior judges cite to those cases. So that's one interesting pattern. As for the question about whether this is a panel study, this is not a panel study. It is basically a 3-year study, 2006 to 2008. I would only say that when we did our study, that was the most comprehensive. That was the latest years where we have the most comprehensive case reports. And in the case of like Malaysia and Singapore, it was already a few decades after they turned into an independent jurisdictions. So I would say there's enough time has elapsed to, if you want to go really independent and cite to your own cases, you could have time to develop that tradition, and yet that's not the case. And another piece of evidence to confirm that this is a very contemporary practice is because, yes, many people, many judges there cite to English cases, but they also cite to other foreign cases, like cases from Australia, from New Zealand, from Canada, from the US, or they cross-cite each other. That's particularly the case between Singapore and Malaysia.
One more question. I just have to warn the questioner and the answer that I can see Gary smiling. We have 2 more minutes to wrap up. So a quick question and answer, and then we will have to draw it to a close. Yes.
Can your data tell us anything about competing jurisdictions? That is to say, does Singapore cite Hong Kong, and does Hong Kong cite Singapore?
They do, and as I said in my previous answer, I think they do cite off each other, but the most heavy traffic is between Singapore and Malaysia. And I would surmise that's because of their common heritage to another important piece of puzzle that's missing in our paper, let me be honest, and that's the Indian common law system, the Indian Penal Code, for example. And so there are precedents that they cite to how the Indian Penal Code should be interpreted, for example. And that's more obvious in the case of Singapore and Malaysia, but not as obvious in the case of Hong Kong.
Can I just add very briefly that, so yes, the cross-citation occurs between all 3, but definitely in different amounts. And if you're interested in the detail, we do have a detailed table in the paper that shows the percentage of citations to each jurisdiction of all jurisdictions that are cited by multiple of the 3 in the study.
Okay, well, thank you very much. And now I will just call up Jo Ng for the presentation. We are going to be presenting a certificate on stage. Yeah, Jo. I should mention that Joe, I didn't mention where he was from, but it's like he's part of the family here at NUS. He's from Cambridge University Press and is representing the press that has generously given also a book prize award to the authors. My thanks again to the authors, to Cambridge University Press, and thank you very much for an absolutely terrific presentation. And with that, we bring this to a close, and I wish you all the best in the rest of today and tomorrow in the conference. Thank you very much.